guys, welcome to the Think Tank Pop Up Live. So, Richard Allen's lawyers are kind of kicking back. What do you They have a little bit to say about what was happening in this whole my buddy took the evidence thing. So now the one lawyer is pushing back, saying he was basically forced into that and he still wants to continue. So there is paperwork and it's called Verified Notice of Continuing Representation. So this was filed at 7:51 yesterday. So State of Indiana versus Richard M. Allen. So let me hook you up. I'm sitting here waiting for the Kohlberger stuff. And then this comes on. It's like, what? I swear it's never ending, guys. Like, what the actual hell is going on out there? Hey, Dandy. Good to see you, friend. So I have not read through all of this. When I seen it, it was like, no. Hey, Melissa. Good to see you, friend. Yeah, just personally, I'm shocked. Again, this case is just gonna, it's cray-cray. Is this thing gonna end up getting thrown out, guys? Is it gonna end up getting thrown out? Like, oh my God, what the hell is happening? So just let me get a little bit hooked up here and we'll get into this. Holy. Did the snow hit you yet, Dandy? Okay. Let's see, I got that going. So there might be another document out there. I will take a look for it. Mexi, hello. So let's go. Ole. So verified notice of continuing representation and iCloud notice comes now. Attorney Bradley A. Rossi, counsel for Richard M. Allen, and in support of his verified notice of continuing representation, now swears and affirms as follows. 1. On November 14th, 2022, counsel entered his appearance on behalf of Richard M. Allen. Counsel has engaged in the continuous representation of defendant Allen since this time. On October 12, 2023, the court communicated with Prosecutor McClelland, Attorney Rossi, and Attorney Baldwin, at which time the court ordered Attorneys Rossi and Baldwin to cease work on Mr. Allen's case. So look, this is like October 2023, like, whoa. So the chilling effect of the court's emailed order was to essentially strip defendant Allen of his Sixth Amendment right to representation and essentially disarmed attorneys Rossi, Baldwin, and defendant Allen during the week leading up to the scheduled hearing, which was ordered by the court. 3. In October 17th, 2023, email. Attorney Rossi requested a conference to determine what the court, prosecutor, and defense counsel are trying to accomplish on Thursday, especially in terms of what is expected of us while we are on the record in open court. In response, the court ordered both the defense and prosecutor to appear in chambers at 12:30 p.m. October 19th. Oh my God. 4. On October 19th, 2023, Attorney Rossi and Baldwin appeared at the Allen County Courthouse in advance of the 2 p.m. hearing. This was prompted by Attorney Rossi requesting that the parties communicate in advance of the scheduled hearing. 5. Attorney Rossi and Baldwin appeared in chambers on the 19th at approximately 12:30 p.m., at which time the prosecution was present. Attorney Rozzi is of the understanding that the court reporter secured an audio recording of the in-chambers conference. Oh no. Which took place in 2 parts. What? Is this case just falling apart? What the hell? Hey, Perry, good to see you, friend. Hey, Shauna, good to see you. Just what the actual hell is going on with this case now? Let's see here. I don't know what docs you have. Those are okay. I appreciate that. Oh my goodness. So where is this leading you guys? You know? Nice to see you guys coming in. This case, friends, what do you think? Like, what do you think? Is this going to get thrown out? Like, is this just getting that messed up? What the hell is going on? I mean, how did this guy get a hold of these photos is what it's sounding like? How, I mean, he was not, it's sounding like, associated with the case. I appreciate that, Dandy. Thank you very much, friend. So, yeah, I'm getting very, very concerned for this case. And do you know what? I said this the other day when we were talking about this case. I was stuck that it was Richard Allen. Honest to goodness, I was. And now I'm at the point where I don't know what the hell is happening with this case. It's like, are you kidding me? Wow. All righty. So 5 appeared in chambers, approximately 12:30 p.m. Okay. Attorney Rozzi is of the understanding that the court reporter secured an audio recording of the chambers conference, which took place in 2 parts. The court first conducted business as it related to several pending motions by communicating with the parties as issuing rulings on the motions. 7. The court read a prepared statement to Attorney Rozzi and Baldwin, identifying various issues throughout the case through which Attorney Rozzi and Baldwin exercised gross negligence in carrying out their responsibility as counsel to the defendant. Well, I don't know. I'm not finding this okay. I mean, we'll see what goes on with this paperwork, but this is so far very negligent to allow someone access to those files. So let's see here. Gross negligence in carrying out their responsibilities as counsel for defendant Allen. The court then suggested that attorneys Rozzi and Baldwin engage in a discussion outside of chambers regarding all the allegations. Attorneys Rozzi and Baldwin asked for clarification, in which time the court communicated to Attorney Rozzi and Baldwin that there were 2 distinct options. 1, either voluntarily withdraw their appearances and exit the courthouse in advance of the hearing. Whoa. 2, participate in their appearances and exit the courthouse and participate in the 2 p.m. hearing in the courtroom where a media camera was installed. The national media was present and the law enforcement community was seated in the jury box directly behind the defense. At which time court would read the prepared statement into the record and then disqualify both Attorney Rozzi and Attorney Baldwin in the presence of defendant Allen and his family and the general public. Oh boy, guys, this is a mess. This is another shite show. Here we go. Brutal. Number 8. After waiting approximately 1/2 of an hour for Defendant Allen to arrive at the courthouse, Attorney Rozzi, Attorney Baldwin communicated with the Defendant Allen regarding the stark choice that the court had offered in chambers. Defendant Allen reaffirmed his desire to move forward under the representation of Attorney Rozzi and Attorney Baldwin. As of October 24th, Defendant Allen objects to the court's attempts to strip him of his current counsel. Attorney Rozzi and Baldwin. 1. On October 12th, 2023, Attorney Rozzi filed the correspondence within the court. Said correspondence contained a letter dated October 11th, 2023, signed by Defendant Allen, and Defendant Allen acknowledged that he was an heir. He was aware that certain issues regarding crime scene photos were stolen from Attorney Baldwin's office and desired that Attorney Rozzi and Attorney Baldwin continue with their representation of him. Holy. So what do they do in this case? Like, what do they do? So do they all of a sudden, is there going to be a fight here? If he wants to keep this representation, can he override what the judge thinks is the most sense? Let's see here. Good on Rozzi to continue to want to represent, because honestly, a whole new set of lawyers could have delayed Richard's due process even further. Then that would have had a high probability of being dismissed. Where do you think we're sitting now, though? Mexi Texi true. I'm less comfortable with RA trial being delayed than, say, someone like KK because of the stuff on his phone, but nothing seemed like that relating to RA. Yeah, I have not seen any connection to this point. Like, to these two, there's just nothing. And I mean, we've dug. So people working in law enforcement offices should be trusted. It's sad that someone took it upon themselves to do it. It is very sad. But human nature, I don't know anymore, guys. I just don't know. We actually don't know anything about RA. Ellie has never released a single freaking thing other than the gun he admitted to having before they searched his place. Yes. Nothing about computers, electronics, things found on hard drives, not a peep. Damn, judge said jump or be pushed. Yeah, that's basically it. So is that in any way ethical, do you think? Like, what is happening here? Because they want her to now stand down. That's what they want. And it is. I agree. It's a strange one, because honestly, everything leads back, in my personal opinion, to KK and Tony K. That's where I see, in my personal opinion, as they say, don't sue me, just my personal opinion. This has been an ish show. So if these guys stay in, are they going to continue down that Odinism trail? Oh, let's see. Let's see what else we got here, friends. What a mess. After speaking with Mr. Allen, Attorney Rozzi and Attorney Baldwin then returned to chambers, at which time Attorney Rozzi articulated to the court that the court had engaged in an ambush of defense counsel. Kind of sounds like it. Entirely void of due process, and that Attorney Rozzi would withdraw his appearance. But that said withdrawal was not a voluntary withdrawal, because the court made it clear that if Anthony Rozzi did not agree to withdraw, the court would publicly shame him in front of the world, and his client would be forcing him off the case by disqualifying him. Oh, no. Okay. I mean, I'm almost stumbling over words, because how crooked is this place? Like, seriously, what this court is doing, in my personal opinion, is giving the defense a whole lot of room to look for reasonable doubt, and they might very well get a new judge. Wow. So all of the events in chambers occurred without any formal allegations of contemptuous behavior by Attorney Rossi or Baldwin, without a pending pleadings, requested disqualification of defense counsel, and without any pending disciplinary complaints with the Indiana Supreme Court's Disciplinary Commission. 11. In total, Attorney Rossi and Attorney Baldwin have practiced law in the state of Indiana for more than 50 years without a single substantial finding of a disciplinary action against either. This is 12, sorry. At no time while in chambers did the court ever articulate to either Attorney Rossi or Baldwin that their conduct compromised defendant Ellen's defense in any way. In fact, defendant Ellen himself does believe this to be the case. There are no bona fide facts or circumstances wherein Attorney Rossi engaged in gross negligence, nor was there any showing that any conduct by Attorney Rossi resulted in negative consequences to another party, i.e., defendant Ellen. In sum, Attorney Rossi and Baldwin did nothing to compromise Richard M. Allen's defense. 14. Attorney Rossi's oral acquiescence to withdraw his appearance as defendant Allen's attorney was forced, coerced, and driven only by circumstances created by the tribunal, which delivered two terrible opinions: quit or be shamed in public before being disqualified from representing Mr. Allen. 15. The court's premeditated ambush of the defense placed So Rossi, Baldwin, and client Richard Allen in the most compromising position. I believe that to be. That seems to be what I'm seeing. Attorney Baldwin's office and desired that Attorney Rossi and Attorney Baldwin continue on with their representation of him. The intention to read a prepared statement criticizing defense counsel created an impossible ethical bind. If counsel did not agree to withdraw in chambers, the trial court would publicly disbarge their representation of the accused, framing their advocacy on behalf of gross negligence. Sorry, guys. Casting both counsel and the merits of their client's defense in a negative light. This public statement and circumstance created by the trial court risked tainting the jury pool, harming their client's defense, undermining their professional relationship with the client, and possibly, creating an actual conflict for their continued representation. 16. The jury trial in this matter is set to commence on January 8th, 2024, a full 1 year and 3 months after the arrest of defendant Allen. The appointment of successor attorney will prejudice defendant Allen by and through further delay in his case and trial. However, Attorney Rossi moves forward with his representation of the defendant Allen. There will be no need for two newly appointed attorneys to dedicate hundreds of thousands of hours towards a mere review of the discovery, which continues to pour in as recent as late September. There will be no need to marshal all the discovery and return it to the prosecution. There will be no need to bring up to speed new staff members, investigators, and possibility possibly a new set of experts to address the many complicated issues that have already been addressed by the defense. A new defense team would likely result in a shifting of the strategy and approach of Allen's current defense team. I would have to agree with that, which in turn would further delay and compromise Richard Allen's defense. Finally, any successor lawyer would have the convenience of working with Attorney Rozzi to become familiar with the subject matter in a much more efficient and fiscal responsible way. All these truths weigh in favor of Richard Allen's choice to maintain Attorney Rozzi as his counsel of record. 17. There are no circumstances under Rule 1.16 of the Indiana Rules of Professional Conduct which warrant the withdrawal of Attorney Rozzi's representation of Defendant Allen. 18. Attorney Rozzi notices up this court of his intention to move forward with the representation of Defendant Allen until the final disposition of this matter. And then signed, I swear and affirm the penalties for perjury that the foregoing representations are true. Bradley A. Rozzi. I certify that I have served a copy of this documentation by the county e-filing system upon the Carroll County Prosecutor's Office the 25th day of October 2023. Wow. Did you guys see that coming? Boom. Boom. Oh my God. Let me see. What do I have here? Let's take a look. I'm going to try this, but these guys are just like, oh my word. But I'll try. Have a little fox in our life. Maybe, oh, what's this? Are you kidding me? This is funny. There we go. Good Lord, Bertha. The ambushed Delphi defense attorney says judge coerced him to leave double M case, asks for her removal. That's what's going on. That's what's going on. Okay, let's see here. This is going to let me get bigger. And do we even want this? Let's see. No, we don't want that. Okay. The remaining attorney left defending Delphi suspect Richard Allen is asking the judge that the judge overseeing this case be thrown out. Okay. Nope. Nope. Jizzy. Hey. There's a big boom sound. Sounds like, I don't know, like maybe a big pile of snow maybe. Come in here, Jesse. So attorney Bradley A. Rozzi, the sole defense counsel, there we go, still representing Richard Allen in the highly publicized double trial, filed several motions Thursday in Carroll County. Okay, let me see if I can find some more of these. He should continue to represent his client and that the judge should be recused. Allen, who is charged with 2 counts of unaliving. Oh, my word. Lost myself here. The remaining attorney, okay, I'm going to start back up here, friends. Got a little distracted with my girls. The remaining attorney left defending Delphi suspect Richard Allen is asking that the judge oversee the case be thrown out, claiming she ambushed and coerced the defense team to drop out. Attorney Bradley A. Rossi, the sole defense counsel, still representing Richard Allen in the highly publicized double trial, filed several motions Thursday. Okay, Allen is charged with 2 counts in the February 13th, 14th passing of Abby Williams and Libby German close to the Monon High Bridge in Delphi. For the past 11 months, Rossi and court-appointed attorney Andrew J. Baldwin had been preparing defense. So this is the thing. Do you guys think that, do you think she needs to go now? Do you think they got to start fresh with a new judge? It'd probably be easier than new counsel. And if he doesn't want them, if he wants to keep them as his lawyers, can she stop that? The Logansport attorney claims the judge's directive as a result of a leak of the case evidence from Baldwin's Franklin-based office earlier this month would deprive Allen of his right to a counsel and further drag out trial for a case that already took nearly 5 years. This is it. Like, is this going to affect everything? Rossi is asking that next week's hearing be continued as the court and potentially the Indiana Supreme Court considers these latest findings. I was wondering what they were going to do. So October 31st, we'll have to see what comes out. Let me see if I can find any more documents, guys. What do you think about all this? It's like, what? No. So, okay, let me see if I can get some more PDF. What the living hell are they doing now with this case? Oh, my word. Now, there's probably more out there, but as of right now, I can't say that I can see anything else. Now, we've got all the documents we've gone over in previous lives. But as for right now, is there anything that you guys have noticed that you'd like me to take a look at? Okay. Yeah, it doesn't look like there's a lot of doesn't look like there's a lot out there on this yet. So make sure you subscribe, like this with that thumb. Unless you think I totally suck, then I take down too, but something. And share, because it's not, Jasmine, it's not going around like we want it to. Yep. Oh my God. Yeah, that situation is very bad as well, Perry. I will check on that. I'm trying to get a couple things done in like my real life. I don't know what's going outside, but Jazzy's going BS crazy. Let me see if I can find anything else. Give me 2 secs, friends. Okay, I'm looking. It does. Some days, as we know, with the fibro, like I'm not shooting on all cylinders. So if it's a suck-ass day, well, then it is. I apologize. I apologize. Oh, right. Had planes flying around today, but I'm in New York, not Maine. It's true. You don't have time for real life, Franky. You're in roo deep. It's true. But you know what, you guys? I appreciate the fact that you all send me stuff because, a couple of you have my email or my own number. So it is a big help if I'm distracted with something for, even a short time and you guys see that I'm not doing anything. Feel free to shoot me a message on whatever case you guys catch if I'm missing it. Okay, let's see if this is anything else I can find. Okay, right there is what we just looked at. Oh, this is one of 8 pages. Let me look. Rather than legitimate concerns if counsel had engaged in contact. There's a little bit more here. Let me see here. Dun, 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 dun. Oh my goodness. I'm looking at documents and it's like, no, do I want to have information on Britney Spears? Not so much right now. Thanks. No. So, you know what? I'm a hot mess right now. I'm going to read this out. This is a motion to disqualify. This is a different document, friends. Okay, I'll start while it's kind of doing its thing there. So, motion to disqualify. Now the accused by counsel and pursuant to Rule 2.11 of the Indiana Code of Judicial Conduct and Rules B and D of the Indiana Rules of Criminal Procedures respectfully and removes the recusal of change of judge from Judge Francis C. Gull. This is something totally different, guys. How you doing, Tracy? Good to see ya. Hello, Shauna. Last update, still not caught. That's what I've heard too, friends. Okay, so let's see here. What the hell? Okay, for whatever reason. Okay, got it. Let's do this. No, 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 no. There is, like with all this stuff going on, it's just what the hell, world. I haven't seen anything on Brian Koberger yet either. And I got that paperwork finally back from the courthouse saying I'm able to join the pool. Alrighty. So the first one was Rosie. And this one is, let's get in here. Okay. How you guys doing? Motion to disqualify. Ooh la la. Make this a bit bigger for us. Am I in the corner? Yes. Yay. Very bold to recuse themselves, then blame the judge and demand they recuse. Yeah, that demanded they recuse themselves. Yeah, this is just one hell of a case, isn't it, guys? It's like, what the actual hell is going on? Holy. So let me even see. I need to. Thanks for all the thumbs up, guys. Don't forget, if you haven't yet, subscribe, like, and share. Okay, so how am I doing right now? I know. I just can't get over this case, you guys. I just can't get over this case. Oh my God. Just about set. I just can't get over this shite show. I don't even know what to say anymore. I really don't. Okay, I think I'm just about there, my friends. Always something going on in the back, isn't there? Okay. I've got my drink, my vitamin water. I'm ready to dive in. Let's do this. Motion to disqualify. Comes now the accused by counsel and pursuant to Rule 2.11 of the Indiana Code of Judicial Conduct and Rules 12B and D of the Indiana Rules of Criminal Procedure, respectively, and moves for the recusal and of change of judge from Judge Francis Siegel. We have lots of seagulls around here. Everywhere you look, there's beach chickens. So Rule 2.11 of the Indiana Code of Judicial Conduct requires a judge to disqualify himself or herself when the judge impartially might reasonably be questioned, such is the case in this cause of action with the reasons described below. 2. The comments to Rule 2.11 provide additional guidance. So 1 of 2. Under this rule, a judge is disqualified whenever the judges impartially might reasonably be questioned, regardless of whether they are specific provisions of paragraphs A through 6 apply in many jurisdictions, and term recusal is used interchangeably with the term disqualification. 2. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. And 5. A judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there is no basis for disqualification. 3. Judge Gull has removed and concealed or allowed to be removed by the clerk of Carroll County defense, pleading from the chronological case summary in violation of the Indiana Supreme Court administrative rules. Those pleadings include Frank's motion filed September 18th, 2023. Frank's memorandum filed September 18th, 2023. 3 affidavits. Warden Gallipo, Sergeant James, Sergeant Robinson filed October 10, 23, and the affidavit of the leaker Mitch Westerman. Judge Gall has not removed or hidden any state filings. 4. Indiana Access to Court Records Rule 2A provides a pertinent part. All persons have access to court records as provided in this rule. That certain persons have greater access to court records. The commentary to ACR Rule 2A is that all persons, including members of the general public, the media, and commercial and non-commercial entities, are entitled to the same basic level of access to court records. And ACR Rule 4 provides that a court record is accessible to the public except as provided in Rule 5. ACR Rule 5A provides that certain entire cases shall be excluded from public access without notice of exclusion, but this entire case has not been declared confidential by statute or rule and meets none of the other criteria laid out in ACR Rule 5A. ACR Rule 5B provides the process for excluding individual case records. However, none of the 13 listed grounds for excluding public access to the records secreted from the docket in this case apply to above referenced documents, which have either disappeared from the CCS or are inaccessible to the public, nor were their documents filed using procedures required ACR Rule 5B, i.e., filing on green paper or filing electronically as confidential document, along with ACR form identifying the specific grounds on which exclusion is based by secreting pleadings from the docket without following the access to court records rules. Judge Gall has or has allowed violations of public access because those acts have only shielded documents from the defendant. These actions clearly demonstrate a lack of impartiality and fairness, of violation of Judicial Rule 1.1, compliance with the law, and Rule 2.2, impartially and fairness. Have you guys ever tried to talk when your tongue's stuck to the top, like to the roof of your mouth? It's not easy. Hydration. October 12, 2023, Judge Gall instructed appointed counsel to cease work on Mr. Allen's case, which interfered with the attorney-client relationship and prejudiced the accused by denying him the timely, effective representation guaranteed him to the state and federal constitutions. Yeah, this is just a shite show. Sorry. So, October 19th, 2023, Judge Gall conducted critical stage proceedings in chambers outside the presence of accused, even though she had ordered him transported while he was available. She then did the same after placing his attorneys in an ethical dilemma and again creating a public record outside the presence of the accused. This ignored clear precedent. So what's going to go on here, friends? Is this turning into a shite show? Because it looks like it for me. Oh my word. Let me just see. Okay. Gasp. Thank you. But yeah, leave a nice comment. Don't think I've ever seen one bad comment in here, James. Best channel and chat on YouTube. Hey, thank you ever so much. No, it does not happen very darn often. Every once in a while, a troll will pop in, but we get rid of those fast. Yeah, I couldn't agree more. I couldn't. And we're just getting more and more really great people. Did anyone else hear allegedly this main guy apparently talked to 2 other suspects? 2 been arrested. This guy's still on the loose, possibly 1 more. Oh la la. He's straight saying the court is being shady. Allegedly, my goodness. Yeah, I would say they're loophole lawyers. That's a good way to put it. No, I saw something, a warrant being issued, but it was for only 1 guy. Oh my word. Only one way we can fix these. Lawyers don't commit crimes. I agree. It was brought up earlier a few times, but I'm not sure if it's another jump on a bandwagon to get more likes, but it's caused a bit of stir. Which channel? Well, I mean, I don't need to know which channel. What was that topic? That warrant? It really does sound like that's a good way to put it. It sounds like the defense is having a meltdown. Is that well water? Next hearing, Rizzo will be saying, I can't have a fair hearing with this judge for some reason. She doesn't like me. Well, we're just now starting to add flavored shite sprinkles on this big nugget bowl of shite we're staring at. Delphi is a mess. It's such a mess. Oh my word. Okay, let's see here. Good Lord, Martha. So I do like how they put this. On October 19th, 2023, Judge Gall ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals. The choice presented was to suffer a public shaming and to be removed from the case or voluntarily withdraw. That's just not cool. I don't think that's good. Despite defense counsel requesting clarification as to the topics and or motions to be addressed at October 19th, 2023 hearing, she gave defense counsel no notice of her plan to force withdrawals or remove them, thus denying counsel the opportunity to adequately refute her accusations. So do you guys think this is truly what's going on? Is she as shady as they're making her sound? Because, oh my word, she's sounding pretty sus. Holy. That same day, Judge Gall had prepared a statement that she threatened to read to the public, alleging defense counsel was grossly negligent in their representation of defendant Allen. Judge Gall's complaint was more about not having control over counsel than any legitimate concerns that counsel had engaged in conduct that compromised Richard Allen's defense. A general summary of Judge Gall's complaints are as followed. So what we got little, on the bottom, what's the word, guys? That. Alrighty. How come I'm not even? Don't I hate it when it just goes blank? It's gone blank. All of this stuff has got my brain rattled. I tell you what, my brain's scrambling from what? What? Oh my God, no. And that's what this has been like the last few days as far as this case. It's like, oh, those families, what are you guys doing? Can you imagine being the families? Wow. Okay, so a judge shall comply with the law, including the Code of Judicial Conduct. 2, a judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. And I guess from their point of view, this has not been impartial. Yep, some pretty strong words. Oh, yeah, absolutely. I have it even while I'm live streaming. It's one of those moments. Have you ever looked into the abyss? That's what this case is. This is insane. Yeah, I do. I'll be reading this stuff and it's like, what? So now we've got a judge trying to get rid of 2 defense lawyers, and the 2 defense lawyers are trying to get rid of the judge. So this means this trial, this case is on hold until these lord and masters of the case figure it out. Ambushed, I tell you, bamboozled, hoodwinked. Yeah, she's a special judge. All sorts of ways, I'm thinking. Yeah, according to the defense. Bamboozled, I say, bamboozled. Oh, like, wasn't she? Her eyes were like, there's smoke coming out of her ears when she was saying that these guys did this. But now I'm really starting to wonder. It's a bamboozling legal team. Discombobulated. I haven't heard that word for a while, discombobulated. What about the judge recently seen texting her bailiff right about the case? Oh, these people. Yeah, discombobulated. You bet, friend. Ugh, duh. Okay. So let's see here. We finished off. Judge Gall's complaint was more about having no control over counsel than any legitimate concerns that counsel had engaged in conduct that compromised Richard Allen's defense. A general summary. Okay, here we go. A press release, generic in substance, was issued by the defense in November 2022 before the court's gag order and only after repeated press conferences by the prosecution. Allen's response: the intent was only to level the playing field. This was well within obligations of defense counsel by established guidelines. She never expressed any concerns over the multiple press conferences by the prosecution. Ooh. B, 2 motions filed by the defense, one of which addressed the health and safety of defendant Allen, and the second one which addressed the immediate transfer of the accused due to not so coincidental and undisputed facts that individuals engaged in Norse paganism, here we go, practices may have not only deleted the 2 girls, but they were also escorting defendant Allen around the prison at the same time his health was in rapid decline. Here we go, guys. Okay, this just made a sharp left again. What the what? Oh, lordy lord. Yeah. Ellen's response: the court had previously ordered that the accused transferred to state prison at the request of the Carroll County Sheriff. His mental and physical health began an immediate decline. Prison guards in the area had Odinistic emblems on their uniforms, which endangered their client after Odinist's connection was exposed. Okay. The defense had videos of the patches and the guards admitting they wore them, but they'd said they were not Odinists. We have to remember this. They said that they were what? Norse. They're heathens, right? Remember, they said they're heathens, not Odinists. They said they were damn heathens. All right, all right. So here we go. The Odinist connection was exposed, allegedly. The defense had video of the patches. The guards admitted they wore them. The defense had previously noted a connection between the passings and Odinism. The patches have since been removed. Mr. Rossi cited instances of not taking care of this man. Those filings were within the obligation established guidelines imposed for effective representation. C. Mr. Baldwin had drafted an email to co-counsel, but sent it to the wrong person due to self-populating in electronic mail. What? Mr. Baldwin had drafted an email to co-counsel, but sent it to the wrong person due to self-populating in What the hell's that all about? Ellen's response: this was an accident that happens routinely to most people. The intended recipient, what the hell? Attorney Bradley Rossi and the unintended recipient shamed the first three letters of their names. The email attachment contained no substantive information, just a bare bones outline of a tiny portion of discovery received by the defense in this case. Okay, guys, help me make sense of what I'm reading. What? Hydrate, Frankie. I know. Yeah, sometimes I do, and it's like it does. It feels like my tongue is like glued to the roof of my mouth. I'm like, bleh. Okay. If intentional by defense to delay, which it seems to be, what's the purpose? What do they gain by delaying and peeing off the judge? That's it. Time served. Absolute shambles. Yeah, that could be more time to come up with the rest of the story. Yep. Yep. For crying out loud. They do. The subjects. Yes. That's what you're totally right. The subjects. God save the king, even though Charles is a clown. Oh my God, you guys. Okay. Back at it. So let's see here. The court alleges that Mr. Baldwin put improper statements in his frank memorandum, not false or misleading statements, just improper in her opinion. Ellen's response: the court had disdain for the defense for not filing it under seal, even though there was no order to do so. That memorandum was demanded by the prosecution before there could be a Frank's hearing. It is an impressive piece of legal writing and has been launched by expert defense counsel across the nation. It again was required by applicable guidelines that Mr. Rossi has filed a tort claiming notice to preserve the rights of his client. The court opined that this action amounted to gross negligence. Ellen's response: the filing of the notice was intended to preserve the rights of a man who was shuttled off to one of the most secure detention units in the state, locked up and isolated with only a tablet, which was often dysfunctional. The guy's got a damn tablet. Poor him. No, no, no. What do you mean he's got a tablet? To communicate with the outside world. Ellen has no ability to speak with his wife in private, as his phone calls were always recorded. Ellen's own attorneys were required to make in advance reservations to visit him at the prison. It's entirely impractical that Ellen would have the means to prepare his own tort claim notice and or secure private counsel to do so. F. Mr. Baldwin had hired a lawyer to represent him in this matter. Ellen's response: this was not true. Mr. Baldwin was betrayed by a friend, and there was subsequent related unaliving. As a friend and colleague, David R. Hennessy suggested he need a lawyer to speak on his behalf, and he volunteered. No fee was arranged with the two. The court also alleged undersigned had put volatile facts in the memorandum regarding possible sanctions or disqualifications. The true facts in this criminal case are often volatile. There was no untruth. Okay, I just like some of this stuff. I don't believe it personally, but that doesn't mean that there's no truth to it, right? The dissemination leak of crime scene photographs in which neither Attorney Rossi or Attorney Baldwin had knowledge of nor participated in. Ellen's response: the affidavit of Mitch Westerman, previously filed. Now, I'm pretty sure we have seen that. I'll have to look back. Guideline 1.1 of the Indiana Public Defenders Council Performance Guidelines for Criminal Defense Representation states the paramount obligation of criminal defense counsel is to provide zealous and quality representation to their clients at all stages of the criminal process. Similar obligations are recognized by the American Bar Association, the National Legal Aid of Defender Association, the National Advisory Commission on Criminal Justice Standards, and Goal and Rule 1.1 IRPC. 10. Everything cited by Judge Gall as concerning was either not attributable to Attorney Rossi or excellent and ethical lawyering in the best interests of his client's defense and mental and physical well-being. 11. Throughout this pendency of the proceedings, the defense was exposed untruths by law enforcement, withholding of exculpatory evidence by the prosecution, and discovery violations about which Judge Gall showed no concern and did nothing. 12. The court has routinely expressed unbroached offense let's try that one again. 12. All right. The court has routinely expressed umbrage at defense counsel's representations through investigations and filings while silently abiding the prosecution's discovery delays and false statements by them or their agents. Ooh, 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 ooh. Getting a little feisty there with the words. 3. October 9th, 13. 3 was a long time ago, right? 13. On October 19th, 2023, Judge Gall coerced an oral request to withdraw from Attorney Rossi that did not comply with Rule 3.8H, Indiana Rules of Trial Procedure, and further coerced an oral request from Attorney Baldwin to withdraw as co-counsel in this cause. Judge Gall has exhibited a lack of concern and taken no action to protect the physical and mental health of the accused. 15. Although, no, back up. Throughout these proceedings, Judge Gall has exhibited a bias and prejudice against the accused and his attorneys and in favor of the prosecution. Well, maybe it's because you're coming up with demon sporns, little frickin' horn sprogs. Just my personal opinion. Okay. Pointy little sprogs. 16. Counsel for the defendant, in my opinion, don't sue me. Good Lord, Martha. Counsel for the defendant are appointed, pauper counsel, and upon appointment, judicial control and oversight of the appointed counsel is inappropriate. The court cannot and should not dictate the process of representation or improvidently curtail the representation of counsel. It has done so without notice to the defendant or his counsel, affording them an opportunity to be heard. It's also done so in its own accord without any precipitating motion or request. No due process has been afforded. 17. Rule 2.11 of the Indiana Code of Judicial Conduct requires a judge to disqualify himself or herself when the judge's impartially might reasonably be questioned. Such is the case in this cause of action for the reasons described below. Number 18. Rule 1.2 of the Indiana Code of Judicial Conduct states, a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety at the appearance of impropriety. 19. As previously stated, Judge Goss strong-armed, they strong-armed attorneys Rozzi and Baldwin. Whoa. With a prepared statement that he intended to read into the record had either attorney resisted her efforts to remove them from the defense. Like, why is she doing this? Why? She's messing. She's been messing with this. Whether it's been purposely or not, it's been an ish show. It's been a total ish show. Within minutes, Judge Gall took the bench, started the record, and informed those present that the viewing public that there existed an unexpected turn of events, with the defense team withdrawing from the case. Judge Gall further stated that these circumstances were clearly out of our control. The only clarity offered up by these statements is they were entirely inconsistent with her actions in chambers just minutes earlier that forced the attorneys to consider withdrawing this matter. The words that run afoul of Rule 2.1 as they demonstrate a tribunal's lack of integrity and partially towards the public and IRSUP defendant Allen's right to competent legal representation. 20. Rule 2.2 of the Indiana Code of Judicial Conduct requires that a judge shall uphold and apply the law and shall perform the duties of judicial office fairly and impartially. Comment 1 to the rule states, to ensure impartiality and fairness to all parties, a judge must be objective and open-minded. I mean, that we got to admit that's true. And if she is leaning one way or the other, that's not a good look. 21. Rule 2.15 of the Indiana Code of Judicial Conduct in pertinent part states, B, a judge having knowledge that a lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, shall inform the appropriate authority. It does not indicate that such opinion of the court allows removal of appointed counsel with due process against which of the accused. 22. Judge Gull has violated rules 1.2, 2.2, 2.3, 2.6, 2.8, and 2.11 of the Indiana Code of Judicial Conduct. Bradley A. Rossi, I swear and affirm under these penalties of perjury that foregoing representations are true. Certificate of service. And again, I certify that I have a copy of this document by counting the e-file system upon Carroll County Prosecutor's Office, 25th day of October, 2023. And again, Bradley A. Rossi is, I don't know. What is this? You guys might know better than me. The file number, or is this associated basically with the defense team? Things I don't know and would love to know. So, guys, there's the Ish Show. Dave, hello. Do you know what? I had no idea you had a channel, friend. So I added you to my description. So I hope that helps you a little bit. I was surprised. You've never said anything. So I'm doing something. I'm like, no. And I got looking and I seen the owl. I'm like, oh my God, that's Dave. Oh, you didn't either. Oh, you know what, Shauna? Isn't that the truth of it all? It has been so confusing. And it's been so much, and he hasn't even been to trial. I mean, well, sad. Knew everything. I know it's going to take longer, but I think you're right. Like, oh. Any news on the gunman? Is he still, well, there's two of them, right? Oh, no. What am I missing over there now? Hold on. What are we doing? Okay. What? Okay, let me get out of here. I feel as though I have missed something. Okay, we got the new filings, right? We've gone through them. What is going to be the result of all this Ish? Rick is innocent. Attorney Allen's. Oh, Allen's lawyers. Well, guys, what do you think? This is what we've got. I am not seeing anything else. Let me double check. Gross negligence. Okay, we just went through that. 8. Is there another one? We're up to speed for this moment, guys. I'm not seeing anything else that we might have missed. So far. Oh, Tracy Wright. It's getting that way. Going to pick up your little? Yeah. Well said. They need to release the transcript from the court reporter. So, guys, what do you think? Do you think that are they going to scratch it? I'm very, very concerned. Right back at you, friend. Right back at you. Okay, let me see. Yeah, we're on point. So now what I'm curious about is, anybody know what's going on? Oh, this is it. This is it, friend. No, they can't. I know. It's just a person doesn't even know. I get going through this and I'm like, what on God's name am I reading now? Like, are you kidding me? I mean, I hope that didn't sound offensive to anybody, because I didn't mean that to sound offensive, but I just don't know what's going on. Like, now we've got a defense calling out the judge. The judge doesn't like the defense. We've got Odinists on one side. We got Richard Allen on another. We got Ron Logan over there still hanging from a twig. And it's like, what the actual hell is going on with this case? I can't imagine Odinists. I don't see it. Each to their own. I mean, yeah, it sounds like a high school debate team. So I'm going to double check here. You guys probably know a lot better than I do if that guy that did that mass shooting, did they get him? I want to know. Let me check. Okay, so it's saying still at large, guys. 18 at least have passed. But yeah, what we know is he is. Do you guys think he's gone too? Did he go unalive himself? I mean, a lot of them do that, don't they? They go out, they create all this chaos, and then they go take the coward's way out. I'm going to keep on top of that. If I seem to be missing it, do you mind sending me off a message? You mods are like awesome at helping me like that. I appreciate it. And anybody, I mean, I'm easiest to reach on Discord. You can also email me, but I'm bad with emails, I have to admit. Okay. All right, guys. Well, here we go. Uh-oh. Yeah, he might have. Let me just get back up here for a second. Oh, you know what? I didn't think of that. I really think that this comes from the judge was upset from the 136-page doc, right? Oh my goodness. Yeah. I just looked and there hasn't been an update. So did you hear about it, or is this just the first time you've heard about it? That he unalived, they're up to 18 now. Bye-bye. Yeah, you seen that coming, right? Person seen that coming. And if it's the end result with this one, it wouldn't surprise me. Not with the other shooter, not with this case. Okay. I will keep my eyes peeled. I appreciate every single one of you. I'll see you in the next one. Bye.